Hello everyone, welcome back to my YouTube channel, the BH Law Entrance Exam by your coach Bakul Hanspal. And today we're going to start with the other topic which is torts. So torts वाला ऐसा topic है जो बहुत important है that if you do not do this topic then I won't suggest you to sit for the Clat exam because that's one of the foundations of your law, right? So legal reasoning का ये part है. We know that passages come up, principles also come up, right? And on the basis of that we need to answer. But I would suggest that if you have some kind of determined knowledge, so in that case it would be easier for you to move ahead. Okay, so I would say torts is a very, very easy topic as compared to other topics like constitutional law, contract law, because over there at times you need to pick up bare acts. However, there is no bare act in terms of tort law. Tort law is something which is completely derived out of case laws, out of, I won't say statutes, but out of what already has happened in the past, what happened in the past rather, right, in different countries. So it has been picked up from different countries, right? England is one of them. ठीक है, तो इसका सबको देखेंगे. तो देखो हम काम काम की बात करेंगे. Tort is something which is wrong. It's a civil wrong. It is derived from the Latin word tortum, which means twisted. Now, we know that there is no fixed source to study tort from. Unlike contract law. Contract law में जैसे मैंने constitutional law की क्लास ली थी. I'll put this on the I button as well. Constitutional law, I had picked up constitutional law का bare act for the government side, right, to teach. Now, for torts, there is no particular site. There is no particular, I would say, bare act that you would find. It's something that is completely on the basis of the case laws. So I have found in out of all the sources, I think that NCRT wala source for class 12, that's one of the best sources because it contains almost everything. A few things which are not there, I'm gonna include. Okay, I'm gonna tell you everything. Okay, so पहले thought के बारे में बात करें. For example, if someone sits on a chair and I just pull back the chair and the person falls on the ground, right? What is it? राइट, मैंने किसी का मर्डर नहीं करा ऑफकोर्स, मतलब क्रिमिनल लॉ तो हो नहीं सकता, राइट? उस बंदे को थोड़ी सी चोट लग गई, राइट? तो उस केस में आई हैव डन समथिंग, आई हैव कमिटेड अ टॉर्ट. Okay, in the same way when I talk about defamation, if a person, let's suppose, has defamed a particular person, that is covered under tort. However, it is covered under IPC as well. Now when we'll study IPC, I'll cover that as well. But however, if you see that if a person says something, right, which is of course wrong, which is false, right, and which degrades the reputation of a particular person in the community of right-minded people, that is defamation. That is also part of tort. For example, if I have a gun, right, and the person in front of me thinks that I have a loaded gun, right, and I point that particular gun towards him or her. Now I know that this particular gun is unloaded, right? But according to him or her, it is loaded. So it has created some kind of fear or apprehension in mind of that particular person. So therefore, this would be considered as assault. Now we'll study about what is assault, what is battery, right? So this is tort, right? Tort is civil wrong, we know civil. However, it's also criminal in some particular circumstances, and that's majorly in case of libel. Libel is a kind of defamation. We'll read about it. You need to remember MC Satalwad. MC Satalwad is the first Attorney General of India. For your quality purposes as well, you should remember Attorney General is mentioned under Article 76 of the Indian Constitution, and Advocate General is mentioned under Article 165 of the Indian Constitution. What is Attorney General? We'll study this in the upcoming sessions. But for now, you should just know that Attorney General is someone who represents the government, who represents the central government in matters, in legal matters, basically. And however, in case of 165, it is Advocate General, basically represents the state governments, state government, particular state government in legal matters. Okay, and for example, shall I'll tell you a particular trick also later on that if you have a particular center article, then how can you get the corresponding state article, right? I'll tell you very soon. तो अगर हम देखें अनलिक्विडेटेड डैमेजेस, जैसे हमने कॉन्ट्रैक्ट लॉ पढ़ा था. कॉन्ट्रैक्ट लॉ में हमने क्या पढ़ा था? ऐसा बनता है कॉन्ट्रैक्ट, ए और बी ने कॉन्ट्रैक्ट करा कि जो ए है वो राइस खरीदेगा, सिंपल है, वो राइस खरीदेगा बी से, ठीक है, अराउंड आई वुड से 7,000 रुपीज, राइट, वर्थ 10 kgs ऑफ राइस, ठीक है. Now it is mentioned, okay, and that too, if B, no, what did I say? I said that A is supposed to, chalo, consider this that A is supposed to deliver to B. Now it's mentioned in the contract that A is supposed to deliver this particular item to B by, I would say, today is 3rd of March. So let's say by 13th of March. He needs to deliver it by 13th of March, right? And let's suppose if he does not deliver by 13th of March. In the contract also it's mentioned that you have 15 days of your this limitation period. Now what is limitation period? Limitation period, as the name suggests, it's something which is limited, right? अब कैसा भाई, अब limitation period एक stipulated period होता है. इसका मतलब होता है कि मान लो 13 मार्च के बाद जो बाकी के 15 दिन निकलते हैं, अगर जो अग्रीव पार्टी है बी, उसने अपील नहीं करा कोर्ट में, उसने फाइल नहीं करा केस ए के अगेंस्ट, तो उस केस में उसके पास वो राइट खत्म हो जाएगा कॉम्पनसेशन लेने का ए से, जिसने डैमेजेस सफर कराया। राइट, आर यू गेटिंग माई पॉइंट? सो इन दैट केस दैट इज नोन एज लिमिटेशन पीरियड। राइट, एंड मान लो वो लिमिटेशन पीरियड की जैसे 13 मार्च को उसने डिलीवर नहीं करा, सो इन दैट केस लेट्स सपोज ही अपील्स इन द कोर्ट ऑफ लॉ ऑन 15 मार्च। ठीक है, and it's also mentioned in the contract that A is supposed to then compensate 8K to B if he fails to deliver the aforementioned items as that had been planned. नाउ अगर हम बात करें ना कि 8K है, 8K समथिंग विच इज वेरी स्टिपुलेटेड अमाउंट, इट्स an amount which is already mentioned in the contract, so that is known as liquidated. What did I say? Liquidated amount. However, when we talk about if you want to give compensation in case of tort law, that is unliquidated. Now let's read the definition of unliquidated so that we get some more clarity. Unliquidated damages can be defined as a sum of money that cannot be foreseen or assessed by fixed or predetermined formula. As again, as the words like fixed or pre-decided formula. All these they try to emphasize over that we are not using anything which is fixed, right? We are not using anything which is liquidated. It's not mentioned in the contract. In case of tort law, first of all, the tort happens, and then after that, you see that what kind of damage has happened. On the basis of that only, you're going to assess that कितनी चोट लगी है बंदे को, कितना loss हुआ है. On the basis of that, you're going to give money to him. ठीक है? So that is unliquidated damages. Okay. Um, Now we should also remember one more thing. Like for example, when I talk about some kind of, I would say, damages. So damages क्या होते हैं? देखो, remember the word damages. This would be used very frequently throughout tort law, also throughout various, I would say, civil law matters. Damages is not injury, right? It is known as compensation, monetary compensation. Monetary compensation मतलब money, right? So this is monetary compensation. 8,000 would be given to B if A fails to deliver the items to B. So that is known as 8 gives the damages over here. Now two basic kinds of remedies is given to a particular individual जो हमने contract में पढ़ा था. One is damages, one is compensation, that is right, and other one is specific remedies. जो मैंने आपको पेंट वाला एग्जांपल दिया था कि 4 वॉल्स को पेंट करना था एक पर्टिकुलर कलर से, जो पेंटर था उसने सिर्फ 2 वॉल्स को कलर कर दिया उन पर्टिकुलर कलर से. कॉन्ट्रैक्ट को जो रेमेडी जो बी को देनी चाहिए अब ए को, ए मतलब वो बंदा जिसने डेप्यूट करा था बी को वो पेंट करने के लिए, तो वो क्या रेमेडी होगी, तो बाकी के वॉल्स को भी पेंट कर दे, तो दैट इज स्पेसिफिक रेमेडी. नाउ इफ यू सी इन केस ऑफ इंजंक्शन ना, इंजंक्शन, व्हाट इज इंजंक्शन? इंजंक्शन इज आल्सो काइंड ऑफ पर्टिकुलर रेमेडी that is given to people. Now for example, I'll give you some example. There's this particular case which is going on, right? And in this particular case one person is accused, and that person is asked by the court to not leave the country, right? Right, for the next, I would say, 2 to 3 months, or maybe till the case is going on. In that case, that is a court order that the court has delivered, right, to that particular person who is accused, and that could be interim as well. Interim means in between the proceedings. Now, अगर बंदा accused है, मतलब बंदे का ना ही conviction हुआ और ना ही acquittal हुआ. Conviction का मतलब ना ही बंदा guilty declare हुआ, acquittal का मतलब ना ही बंदा innocent declare हुआ. Right, वो केस अभी भी proceeding में चल रहा है, because हमें पता है कि the whole legal system is associated with this one, it's a so-called phrase which is तारीख पे तारीख, right? So जहां पर जो इंजंक्शन का मीनिंग है, इंजंक्शन का मीनिंग इज व्हेन कोर्ट इज गिविंग यू ऑर्डर्स इन बिटवीन द प्रोसीडिंग्स, और द कोर्ट इज आस्किंग यू टू डू समथिंग और टू नॉट डू समथिंग, दैट इज नोन एज इंजंक्शन. ना हमने ब्री कॉन्ट्रैक्ट का एग्जांपल लिया, ए और बी राइट्स वाला, हमने टॉर्ट का एग्जांपल लिया. अब बहुत इंपॉर्टेंट है, इफ यू लुक एट द डिफरेंसेस एज वेल. नाउ if you talk about tort is a civil wrong in which the remedy is action for damages, breach of contract is a breach of promise, the primary remedy of which is performance of the contract. It could be performance also, it could be in case of compensation also. Damages are always unliquidated, जो मैंने बताया damages are liquidated, it's always mentioned the contract. Motive may be taken into consideration. Now it's something which we will learn in the upcoming slides as well. Motive में थॉट्स इंटेंशनल भी होते हैं, वो एक्सीडेंटल भी होते हैं. ठीक है, तो मोटिव इज टेकन इनटू कंसिडरेशन इन केस ऑफ, उसके बेसिस पे पनिशमेंट होती है, बट मोटिव इज मेजरली इररेलेवेंट इन दिस केस. ठीक है, आपसे गलती हुई तो आपसे गलती हुई. हाउएवर आई वुड से breach of breach of contract में I would say this statement is still bit contradictory, because अगर मैं आपको example दूं ना, let's suppose if there is a singer who's supposed to perform somewhere. Now if let's suppose he gets some throat infection and he's not able to perform, right? He was supposed to give his performance the very next day, but his throat got infected due to something, and therefore he's not able to discharge the particular contract that he had signed with the person who was throwing up the party, let's say. तो उसके केस में ना, अगर मैं बात करूं, उस केस में वो ब्रीच ऑफ कॉन्ट्रैक्ट नहीं हुआ, वो डिस्चार्ज ऑफ कॉन्ट्रैक्ट हुआ बाय इम्पॉसिबिलिटी ऑफ परफॉर्मेंस, राइट? आई वुड से दैट्स इम्पॉसिबिलिटी ऑफ परफॉर्मेंस. व्हाई इज इट सो? बिकॉज if you have seen my contract video, I would highly recommend you to see my contract video. Also, one of the clauses or bullet points that we had studied under the impossibility of contract, one of them was that if there is some kind of effect on the subject of law or the subject matter of law, right? So in that case, the contract would be considered dissolved, right? If in turn it has an impact on the contract. तो अगर बंदे की गला ही खराब है, बंदा is not able to sing, then how will he perform the contract? So in that case, motive, somehow you're taking into consideration the person is deliberately breaching the contract. Okay. In the tort law, if the person is bound towards the other persons, however, they're bound towards a specific person. A और B के बीच में contract हुआ. A and B, they are in a legal relationship. Okay. A, who was supposed to deliver the items to B, is bound to B only. However, when I talk about in case of tort law could be I'm constructing a building, right? And I'm doing something on the land. I'm using very harmful chemicals also to make sure that my building does not fall if any earthquake comes. So I'm using very thick, proper mortar, masonry kind of a material I'm using. And let's suppose if all this material falls down, or if this basic structure of my building falls down and someone gets hurt, so I would be liable for that as well in case of tort law. Now we'll study how. In this case कि हम general person से भी जो होते हैं bound होते हैं. In tort, damages may be compensatory or even exemplary damages. Damages, nature of damages is compensatory. It's already mentioned in the contract, so it's sorted for you. However, in case of tort law, it's nowhere mentioned. It's not a contract. That's the reason particular difference box has been given to you. The exemplary का मतलब जो example set करते हैं in the society. Now I'll tell you. Bhopal gas tragedy case, you all must have heard, one of the most popular cases. इस केस में देखोगे the damage that was given to the people, that was exemplary. Let's set an example. However, I would say that is a very negative example because अभी भी people are fighting for it because अभी भी उन्हें नहीं मिला, so they're struggling for it. Three fundamental elements of tort law: you perform something which is wrong, right? Some kind of damage is caused, and then you give remedy. Right? Damage is very different from damages. Remember, damage is injury over here, and when you have an S also added to it, it would mean monetary compensation. Come to this. Sources of laws of torts. Because I've already told you, there is no particular statute or no particular bare act to read torts. There is only your case laws that you can go through, judicial precedents, the kind of different judicial injunctions. Then from there only you can read torts. Okay. However, some kind of things, for example, Motor Vehicle Act of 1988 and Consumer Protection Act of 1986, have all these two laws, particularly इनके बारे में बात करूँ, they have some or the other elements of tort law embedded in them. फॉर एग्जाम्पल, अगर मैं बात करूं मोटर व्हीकल एक्ट 1988, कोई बंदा ड्राइव कर रहा है, अब तो इसका अमेंडमेंट भी आ गया 2015 का. कोई बंदा ड्राइव कर रहा है, अब उस ड्राइव करने के चक्कर में वो रैश ड्राइविंग कर रहा है और उसने दो लोगों पर गाड़ी चढ़ा दी. दैट वुड कम अंडर नेग्लिजेंस एंड दैट वुड इन टर्न कम अंडर टॉर्ट लॉ. ठीक है. अब देखो कितने तरीके के टॉर्ट लॉ होते हैं, ये मैंने बता दिया, पहले भी बताया था. या तो इंटेंशनली करा जाता है, या तो नेग्लिजेंटली करा जाता है, रैश ड्राइविंग एग्जाम्पल दिया, या फिर बंदा है स्ट्रिक्टली लायबल. स्ट्रिक्टली लायबल विल कम अंडर नो फॉल्ट लायबिलिटी. मतलब आपकी गलती थी भी नहीं और फिर भी आप लायबल हो गए. हाउ इज इट पॉसिबल? डिस्पाइट द फैक्ट दैट यू हैव टेकन ऑल काइंड्स ऑफ प्रिकॉशंस, ऑल काइंड्स ऑफ रीजनेबल स्टैंडर्ड्स यू हैव adhered to, but still you're liable. How is it possible? We'll study about it. Two kinds of things are there: strict liability and absolute liability. We'll see to it. Okay. इंटेंशनल टॉर्ट में ये चीज होती है विच इज बैटरी एंड असॉल्ट. अगर हमने पढ़ा हो, डोंट कंसिडर दिस असॉल्ट एज द असॉल्ट विच इज रिटन इन द न्यूज़पेपर. सेक्सुअल असॉल्ट मेंशन्ड होता है, फिजिकल असॉल्ट मेंशन्ड होता है, वो असॉल्ट बहुत डिफरेंट है इस असॉल्ट से. ठीक है. वहां पर हम यूजुअली वोकैबुलरी के टर्म से बात कर रहे होते हैं, बट इधर हम लीगल टर्म से बात करेंगे. वन इज फॉल्स इम्प्रिजनमेंट, वन इज ट्रेसपास टू लैंड, trespass to chattels. Chattels is a movable property. Movable, immovable, I hope that you know. If not, then I would post a particular video also. This particular video is already there on my channel. Property law wali, just go through it as well. Conversion, unlawful harassment. It would include sexual harassment as well. And lastly, but not least, we have defamation. Defamation may we have two kinds: criminal and civil defamation, right? Right. तो पहले हम आते हैं बैटरी असॉल्ट पर. ओके. बैटरी को समझो, जो न्यूज़पेपर में शब्द लिखा होता है असॉल्ट, दैट इज बैटरी. फॉर एग्जाम्पल, इफ आई गो एंड हिट समवन विद माई हैंड्स, दैट वुड बी बैटरी. इफ आई गो, अच्छा, बैटरी डज नॉट नेसेसरली टू बी विद योर हैंड्स ओनली or with the body parts only. It could also mean that if I throw hot water on someone, I'm using, of course, something which is external on a particular person to give some harm. ठीक है. तो अगर मैं बात करूं, बैटरी इज व्हेन यू फिजिकली टचिंग एन इंडिविजुअल. आई एम टेकिंग हॉकी स्टिक, आई एम हिटिंग समवन, राइट? For example, I'm throwing something at someone. That is, of course, battery. However, assault is someone that I have a hockey stick in my hand. I come nearer to that person. I do not hit that person, but some kind of fear or apprehension is created in the mind of the particular individual. That is what? That is assault only, right? तो ये हमें याद रखना है कि बैटरी में डायरेक्टली बंदे को मारते हो, बट असॉल्ट में आप सिर्फ और सिर्फ बंदे को मारते नहीं. देयर इज नो फिजिकल कॉन्टैक्ट एट ऑल. It's just that you're creating a level of apprehension or fear in the mind of the individual. That is known as assault. Remember this. False imprisonment. False imprisonment is something, imprisonment, when you're behind the bars. False imprisonment is that you're not behind the bars, but you're locked in a room, right? तो देखो, इसमें दो चीजें होती हैं, and दो things are already mentioned over here. One of them is a judicial precedent that came after few years of the introduction of this particular concept of tort law. ठीक है? False imprisonment. So, for example, if a person is there, person is locked in the room without his consent, person knows that he's locked in the room, he's not able to go outside. In that case, it would be false imprisonment. For example, let's say um, um, you are there in a particular, I would say, hotel, right? You have not booked the hotel. You've just used the washroom, right? You have gone into the hotel's washroom, and over there you are locked by the hotel people, right? So that is what? That is, it's a very vague example that I'm giving. But when you are confined by a particular individual or by people unlawfully, right? People are not authorized to do so. That would be known as false imprisonment. But you need to remember one more thing in false imprisonment: person who is imprisoned, who is confined, should know that he is imprisoned or confined. Let's suppose if a person does not know, it would not come under false imprisonment. However, sometimes the courts allow actual harm to substitute for the awareness of imprisonment. So even if a person is unaware that he is trapped but suffers injury, the tort of false imprisonment is satisfied. Now I'll give you example. Let's suppose in a hostel room, right? Or if we, like, let's suppose few people are living together. Now two people are living together. One person is sleeping right now, other person wants to go out of the room. So the person goes out of the room and locks the room, right? Now what happens if, let's suppose, there is some problem which is going with the gas stove, right, with the cylinder or with the gas pipeline. Some kind of blast takes place and the person gets some injury. So in that case, person who locked that particular person would be liable, even though he did not have any kind of intention. That came subsequently in the judicial precedents. However, if, let's suppose, the even right, for example, if the person locked the particular room, other person is sleeping inside, person is not aware that he's locked, other person comes back, and the person who was sleeping initially did not get any kind of damage or did not get any kind of injury, in that case, of course, the person who had locked the room would not be liable for false imprisonment. ठीक है? Because उसके साथ इंजरी नहीं हुई. मेजर चीज इज इंजरी. इंजरी अगर होती है तो उस केस में वो फॉल्स इम्प्रिजनमेंट हो जाता है. वो नहीं होती तो फॉल्स इम्प्रिजनमेंट नहीं होता. बट अवेयरनेस ऑफ द पर्सन इज ऑल्सो इक्वली इंपॉर्टेंट. एंड वन काइंड ऑफ, आई वुड से, सब्सिक्वेंट और अ न्यू एडिशन टू दैट, आई ऑलरेडी एक्सप्लेन द सेकंड पॉइंट. ठीक है? ट्रेसपास टू लैंड. तो ट्रेसपास टू लैंड, लैंड के ऊपर भी होता है और लैंड के नीचे भी होता है. फॉर एग्जाम्पल, वी शुड कंसिडर देयर इज अ काइंड ऑफ नेबरहुड. नेबरहुड में है दो दो घर. दो घर के ऑफकोर्स दो गार्डन है. एक पतली सी फेंस लगी हुई है. फेंस बीच में टूट जाती है. कोई बहुत ज्यादा थंडरस्टॉर्म आ जाता है, and one of the trees from one of the gardens falls on some other person's garden. So in that case, you are using some space of the other person's garden. You basically trespassing to his land. ठीक है? तो in that case, but this would not be a correct ideal example. मैंने trespass to land का मतलब बता दिया. But the defendant must necessarily have the intention to interfere with the possession of the land. Right? So for example, let's suppose if a person is renovating his garden, I'll again try to uh, um, just tweak my example a bit. If a person is renovating his garden, if a person has cut a tree, he's deliberately put the trunk of the tree on some other person's garden, breaking the fence. Even if there is no fence, it does not matter, but he is using some other person's space. So in that case, you would trespassing to the land, right? Trespassing to land, it could be on the land, it could be beneath also. For example, if I decide to construct a drainage pipe under my garden, near to my house, under my garden. And I discover that while digging, I found some other person's drainage pipe going beneath my house. That is what? That is also trespass to land. Okay. For example, if I want to construct something, right, I want to construct some, I would say big rods so that I could dry up my clothes, right, on my house only. That particular area or air that I am occupying, that is within my house the ambit. However, I see that some other person's pipe is coming in my house, right from the top. All those pipes that you have through which the rainwater flows, one of the pipes is coming in my house. In that case, you can easily say ट्रेसपास टू लैंड्स पे भी हुआ है, चाहे वो नीचे हो, लैंड पर हो, लैंड के नीचे हो या लैंड के ऊपर हो, इट वुड कॉन्स्टिट्यूट ट्रेसपास टू लैंड. Now trespass to chattels. Now trespass to chattels is movable property. When I take away someone else's movable property, right, that is known as trespass to chattels. ठीक है? As it's written, defendant uses or intermeddles with the chattel, movable personal property, and it causes significant or perpetual dispossession, right? So या तो you are causing some kind of dispossession, you're taking away that kind of thing, or you're depriving the person to use that, or you are damaging its quality, value वगैरह. In that case, it would be trespass to chattels. For example, unnecessarily painting someone else's car, that would amount to chattels. Now, conversion. Conversion is something when you're destroying the property of a person very permanently. Now, this particular thing also came up in the legal studies paper as well, where it was said that एक particular case है जहाँ पर एक बंदे को एक वास दे दिया गया है by some other particular person. He was supposed to return that particular vase, but then he did not do that. Rather, he went away to show this particular vase to someone else, and then that got broken. राइट, तो दैट केस यू हैव परमानेंटली डैमेज दैट पर्टिकुलर वास. ठीक है, कन्वर्जन हो जाएगा, आपके पास ना लॉफुल एक्सेस था उसका, आपको रिटर्न करने की जगह आप कहीं और उसको लेके चले गए और वो टूट गया, दूसरा बंदा इज परमानेंटली डिप्राइव्ड ऑफ दैट प्रॉपर्टी. वास टूट गया, यू कांट गेट इट. हालांकि ट्रेसपास टू शैटल्स में तो फिर भी आपके पास होता है वो जो थोड़ा सा डैमेज हुआ होता है. ठीक है, बट यहाँ पर तो बिल्कुल ही खत्म हो जाता है, उसकी इतनी बेकार हालत हो जाती है कि यू कांट यूज इट. इसका रेमेडी होता है कि आपको उसको रिटर्न प्रोडक्ट को वापस देना पड़ेगा, या फिर इसकी जो वैल्यू है मार्केट में उसका इक्विवेलेंट अमाउंट रिटर्न करना पड़ेगा. ठीक है. Unlawful harassment and intentional infliction of emotional distress. Now, for example, if I call up a particular individual, I want to do a prank with that individual. I call up and say, your son has died, or let's suppose a child has died in a road accident. सो व्हाट डज इट मीन? तो वहां पर उस बंदे को लग जाता है बहुत बड़ा सदमा, राइट. उस सदमा में क्या है, उस सदमा में तो आई वुड बी लायबल फॉर दैट, राइट, क्योंकि आई हैव गिवन दैट काइंड ऑफ डिस्ट्रेस टू हिम despite the fact that I was doing a prank, but still I would be held liable. However, in that case, the intention also equally matters, right? However, the role of intention is not so much emphasized in this case, but in this case, even if you try to do that and the other person dies because of heart attack, can be held liable for that, right? For example, sexual harassment is also one of the cases, right? उसके examples जो unwanted messages भेजना, phone calls करना, that is also one of the examples, okay, that you need to remember. You will get in the passage, just give a read to it. ठीक है, ये तो पीडीएफ कहीं से भी आपको मिल जाएगी, डाउनलोडेड फ्रॉम द सीबीएसई वेबसाइट. डेफेमेशन, कुछ किसी के बारे में कुछ गंदा बोला है, वो सच नहीं बोला, वो झूठ बोला है, वो भी गंदा बोला, दैट इज डेफेमेशन. कि उस बंदे की जो इज्जत है इन द आईज ऑफ द राइट माइंडेड पीपल वो कम हो गई, दैट इज डेफेमेशन. दो तरीके के होते हैं, लिबल एंड स्लैंडर. स्लैंडर से एस से स्पीकिंग याद रख लेना. ठीक है, जब बोलकर किसी को डिफेम करते हैं, दैट इज डेफेमेशन. वाया स्पीकिंग, दैट इज स्लैंडर, वो सिविल डेफेमेशन होता है. Libel is something which is written defamation. When you have written something as it is in permanent form, it is known as criminal defamation because it would be there for the public for a longer period of time as compared to slander जो बोलकर खत्म हो गया. ओके. ना इससे पहले एक चीज मैं बताना चाहती हूँ. ठीक है, दो चीजें होती हैं, इंजूरिया साइने डैमनम. This particular thing is not there in the NCRT. I think only this particular thing is missing. Otherwise, everything has been covered by it. Damnum sine injuria. Now, what is it? You must be wondering, I have just replaced the words. ठीक है, interchanged it. बट इनके अलग अलग मतलब होते हैं. ठीक है. सिने का मतलब हमेशा होता है विदाउट. इंजूरिया मतलब इंजुरी, डैमनम मतलब डैमेज. तो इंजूरिया सिने डैमनम, डैमनम सिने इंजूरिया मतलब इंजरी हुई विदाउट डैमेज. डैमेज का मतलब इसके केस में, जिससे हमने पहले पिछले केस में बात करी थी, डैमेजेस का मतलब क्या होता है? मॉनेटरी कॉम्पेंसेशन. इस केस से, इस सेंस में डैमेज का मतलब होता है मॉनेटरी हार्म और मॉनेटरी लॉस. एग्जाम्पल देते हैं, एक बहुत केस है पॉपुलर, एशबी वर्सेस वाइट. इसके बारे में पढ़ सकते हो. दिस पर्सन, there was this particular line or queue which was waiting to vote. Ashby, he went ahead to vote. He was not allowed to vote. His legal right to vote was violated. तो उसकी legal right की injury हुई, but there was no monetary loss. There is injury without any kind of monetary loss. So it is injuria sine damnum. However, when I talk about damnum sine injuria, other case है, Gloucester Grammar School case है. There was this big school where the most popular maths teacher was teaching. One day, this maths teacher decided to take a transfer to some other school and left that particular school. Over a period of time, what the people or what the teachers in this particular school began to feel, that the attendance of the pure students were going down. The dropout rates of the students was increasing in this particular school. And however, if you see the reverse of this was happening, rates were decreasing and the attendance rates were increasing just because of this teacher, because he taught maths so well. So इस पर्टिकुलर स्कूल को तो फाइनेंशियल लॉसेस होंगे ना, फीस देंगे बच्चों की, तो डैमेज हो रही है आपको. ठीक है, आपकी इधर डैमेजेस हो रहे हैं, फाइनेंशियल लॉस हो रहा है, बट से नहीं मतलब विदाउट एनी इंजरी. आपके लीगल राइट को वायलेट नहीं हो रहा. ठीक है, वो मैथ्स टीचर छोड़ के चला गया तो आपका थोड़ा ना राइट कोई वायलेट हो रहा है, बट इस केस में आपको डैमेज जरूर हो रहा है, फाइनेंशियल डैमेज जरूर हो रहा है. इस केस में आपको इंजरी तो हो रही है क्योंकि आपको वोट नहीं करा जाए दे रहा एशली वर्सेस वाइट में, बट आपको कोई मॉनेटरी लॉस नहीं हुआ है. सो दैट इज सिने डैमेज. समझ में आ गया? आई होप आ गया होगा. नेक्स्ट से स्टार्ट करते हैं हम. नेग्लिजेंस. तो नेग्लिजेंस में कोई चीज गलती से हो गई हो या कोई चीज का ध्यान नहीं दिया हो, दैट इज नोन एज नेग्लिजेंस. देखिए, पर्टिकुलर केस है, दो दो केसेस है, दोनों को देखते हैं. डॉनिक वर्सेस स्टीवेंसन केस. कुछ नहीं था, एक बंदा आया कुछ पीने के लिए एक पर्टिकुलर कैफे में, जिंजर बियर. अब उस पर्टिकुलर कैफे में जिंजर बियर में एक मरा हुआ स्नेल सा अर्थवर्म टाइप पड़ा हुआ था. उस केस में क्या हुआ, बंदे ने रेस्टोरेंट को बोला कि एटलीस्ट तुम ध्यान तो दो, तुम कैसी ड्रिंक मेरे को पिला रहे हो. तो रेस्टोरेंट ने बोला, हमने जिस बंदे से ड्रिंक ऑर्डर करी थी उस बंदे ने ड्रिंक ठीक से नहीं बनाई है. ठीक है, उसने उसको ठीक से इंस्पेक्ट नहीं करा है, तो हमारी कोई गलती नहीं है. भाई ऐसा नहीं होता पहली बार. This is the first example. Now we'll discuss the consequences as well. I'm just giving you scenarios. This is a particular example that they have given. It's not a case law, but however, it could be seen. It's one of the most, I would say, common things which happen in India. टेनेंट रह रहा है, ठीक है, एंड लैंडलॉर्ड इज देयर. ठीक है, बेसमेंट में रह रहा है टेनेंट. यू आर मे बी ऑन द ग्राउंड फ्लोर एंड द बेसमेंट यू आर स्टोरिंग पेट्रोल की गैलन्स. एक दिन लीकेज हो जाती है, आग लग जाती है. ठीक है, हु वुड बी रिस्पॉन्सिबल फॉर दिस? ठीक है, वन इज मैकफियर्सन वर्सेस ब्यूक मोटर्स. कुछ नहीं होता इस केस में भी. वन पर्सन इज देयर, एक बंदे ने गाड़ी खरीदी किसी पर्टिकुलर स्टोर से. अमेरिकन केस है, ठीक है. स्टोर से गाड़ी खरीदी. अब गाड़ी खरीदी, गाड़ी को चलाई, व्हील गाड़ी का बाहर निकल कर कहीं दूर चला गया. ठीक है, तो ऑफकोर्स गाड़ी पलट वगैरह गई, थोड़ा सा हार्म. तो केस में पता है क्या हुआ, वो बंदा गया उस पर्टिकुलर कंपनी के पास और बोला कि मैंने आपसे गाड़ी ली थी और आपका कार कार का टायर तो खराब है. तो कंपनी ने बोला कि हमने टायर तो किसी और से खरीदा था. कार का टायर तो हमने नहीं बनाया, तो मतलब हम तो लायबल होंगे नहीं. ऐसा भी नहीं हो सकता, आपको लायबल होना पड़ेगा, आपकी ड्यूटी थी इंस्पेक्ट करना. इन द सेम इन केस ऑफ रेस्टोरेंट वाला केस ऑल्सो, डोनाग्यू वर्सेस स्टीवेंसन केस, यू वर सपोज टू इंस्पेक्ट द ड्रिंक दैट यू वर गिविंग टू a customer, right? In this particular case as well, the landlord should have been more, I would say, adhered to reasonable standards, and apart from that should have been more careful so that there is no fire which breaks out, right? तो ये चीजें आपको ध्यान रखनी पड़ेंगी in this particular case. Let's read some major things that were drawn out of it. In order to establish the duty of care in relation to ultimate purchasers, it must be proved. Nature of product must be such that it is likely to place life and limb in danger if negligently made. The knowledge of danger must be probable and not merely possible. Now, देखो ऐसा सा काम हो रहा है क्योंकि ये पर्टिकुलर जो दो दो आई वुड से ऑब्जर्वेशंस हैं, ये भाई मैकफियरसन वाले केस से ड्रॉन है। तो अगर आप इसमें देखोगे ना, इसमें तो बंदे का लाइफ और लिम्ब डायरेक्टली, हाँ हाथ पैर तो दोनों ही उसमें थे ना, डेंजर में। गाड़ी चला रहे हो, आपका टायर कहीं और चला गया, सो देन ऑफ कोर्स यू आर एट डेंजर, योर लाइफ इज एट स्टेक। ठीक है, तो आपको ध्यान रखना पड़ेगा, इवन इफ यू आर नॉट द मैन्युफैक्चरर ऑफ दैट पर्टिकुलर आइटम or that particular product which causes damage, still you need to be liable because you have to inspect the whole product that you are selling to the customer. ठीक है, तो नॉलेज ऑफ डेंजर ऐसा नहीं है कि यार अगर जब वो पॉसिबल होगी कि यार अगर मान लो, ये तो वो वाली बात है, लाइक लेट्स सपोज इट्स लाइक 100%, ठीक है, डैमेज का कोटा है, ठीक है, एक पर्टिकुलर प्रोडक्ट में 50% डैमेज होने का खतरा है, ठीक है, 100% में तो पॉसिबल ही पॉसिबल है। तो एक तो ये बात होगी कि यार इसको तो प्रोडक्ट को मेरे को इंस्पेक्ट करना ही पड़ेगा क्योंकि भाई डैमेज तो का पॉसिबल है। लेकिन 50% वाले केस में बोलूंगी यार 50% प्रोबेबल है, ना करूँ इंस्पेक्ट, नहीं, प्रोबेबल में भी मुझे करना पड़ेगा। ऐसा नहीं कि पॉसिबल में करूँ, पॉसिबल तो कॉस्ट करना ही है, प्रोबेबल में तो करना ही करना है। There must be knowledge that in the usual course of events, the danger will be shared by people other than the buyer. ठीक है, देखो, जैसे फॉर एग्जाम्पल, इसके मैं एक और एग्जाम्पल देती हूँ। वन ऑफ द केस वॉज, one of the pregnant women was crossing the road. One person was driving the car very rashly, and he hit some person, some old man on the road. That man fell down. He died. There was blood all over. अब वो प्रेग्नेंट वुमन को देखकर हो गया ट्रॉमा, ठीक है, उस उधर ही बेबी हो गया डिलीवर, उसकी जान भी आ गई स्टेक पर, उसका मिसकैरेज। तो क्या दैट बंदा वुड बी लायबल हु वाज ड्राइविंग द कार? वाज ही सपोज टू टेक केयर ऑफ द पीपल, राइट, अदर देन द पर्सन whom he had killed? देखो, आइडियली देखा जाए तो सबका ध्यान रखना पड़ता है टॉर्ट में, हमने वो डिफरेंस में पढ़ा था टॉर्ट और ब्रीच ऑफ कॉन्ट्रैक्ट में। लेकिन यार एक चीज होती है विच इज नोन एज प्रॉक्सिमिटी। देखो, इट कैन बी इन्फर्ड फ्रॉम द नेचर ऑफ ट्रांजैक्शन, प्रॉक्सिमिटी, द रिमोटनेस ऑफ रिलेशन। दिस पर्टिकुलर कॉन्सेप्ट इज वेरी वेरी इंपॉर्टेंट। जब भी कोई डैमेज होता है ना, तो डैमेज में आपको देखना पड़ता है कि क्या वो चीज लिटरली पॉसिबल थी क्या। अगर वो आउट ऑफ द वे जा रही है तो दैट केस हो सकता है कि मेरे को कॉम्पनसेशन ना देना पड़े। अब मेरे को उस बंदी ने सू कर दिया प्रेग्नेंट वुमन और बोला कि तुम्हारी वजह से मेरा मिस कैरेज हुआ है, यू नीड टू गिव सम अमाउंट टू मी। देखो, आई एम नॉट सपोज टू गिव दैट अमाउंट बिकॉज आई हैड नॉट एक्सपेक्टेड दिस। अगर मैं रैश ड्राइविंग कर रहा हूँ तो मैं इतना एक्सपेक्ट कर सकता हूँ कि सामने वाले बंदे को चोट लग जाएगी या वो मर जाएगा, बट ये सोचकर कि एक प्रेग्नेंट लेडी देखेगी, उसको खून दिखेगा एंड देन उसको मिस कैरेज चलेगा, दैट्स अ वेरी रिमोट थिंग दैट आई एम इमेजिनिंग। सिमिलरली वन ऑफ द केसेस एक और है, जैसे फॉर एग्जाम्पल इफ यू सी दैट देयर इज दिस metro which is going on ऊपर से, because you have metro के paths which are made in the air, right, at a considerable height from the ground, and the metro is moving. There are some kind of like I would say uh, internal shocks, right, or kind of sparks that come out. One of the sparks move down on the ground. They move down, right, to the ground, towards the ground, and over there some kind of fire is broken out. ठीक है, देयर इज एन आउटब्रेक ऑफ फायर नियर अ पर्टिकुलर केमिकल फैक्ट्री विच इज नियर टू इट, एंड वहां पर लोग मर जाते हैं। ठीक है, वो केमिकल फैक्ट्री से वो केमिकल फैक्ट्री से अगर वो पूरा ब्लास्ट हुआ, वहां से पोल गिर गया, ठीक है, बिकॉज वो इतना ज्यादा पावरफुल था कि एक पर्टिकुलर केमिकल बन रहा था। और पोल गिरने के बाद जो आसपास के घर बने हुए थे, उन पर्टिकुलर घरों में भी करंट आ गया, जो गीजर्स बाहर लगे हुए थे, ठीक है, एंड जो लोग नहा उसमें से जो एक बंदा नहा रहा था, उसका वो मर गया बिकॉज गीजर के पानी में करंट आ गया। isn't it very remote? Isn't it like proximity something which is पास में and remoteness? क्या मैंने सोचा होगा कि यार मेट्रो ऊपर से चल रही होगी, उधर से कोई स्पार्क गिरेगा, कोई कोई इलेक्ट्रिक शॉर्ट सर्किट होगा, उधर से वो स्पार्क केमिकल फैक्ट्री पे गिर जाएगा जो बहुत भयानक केमिकल बना रही हो। पहले मतलब कोर्स अगर आप एक एरिया में भयानक केमिकल बनाने का भी लाइसेंस चाहिए, स्टिल आप एक केमिकल बना रहे हो जिसका ब्लास्ट हो जाता है, उससे पूरे एरिया कंपाउंड की इलेक्ट्रिसिटी चली जाती है, पोल में आग लग जाती है। जो पर्टिकुलर पोल घर के पास बना हुआ था, उसमें जो गीजर्स बाहर लगे हुए थे, बहुत कुछ ऐसे भी घर होते हैं जिनमें बालकनीज में गीजर लगे होते हैं, उनमें आग लग जाती है, एक बंदा नहाते नहाते मर गया। इट इज वेरी रिमोट, यू कैन नॉट इमेजिन सच काइंड ऑफ डैमेज वुड हैपन। Max to max, you can just imagine that the pole got fire. But in that case, even if the pole, right, got some fire on it, even that is too remote to imagine. That is not proximate. Right? But ज्यादा से ज्यादा क्या हो सकता है, केमिकल फैक्ट्री में आग लग गई, लेकिन इतनी बड़ी बड़ी चीज से ये बंदा मर गया, दैट इज टू रिमोट। इन दैट केस आई एम नॉट सपोज टू गिव कॉम्पनसेशन, सो यू टू टेक केयर ऑफ दिस प्रिंसिपल एज वेल। Now, no fault liability. Now, no fault liability is something. Now, दो particular चीजें हैं इसमें, strict liability and absolute liability, and we are left with very less part. I think I'll continue with this in the next session, because the session would become too long otherwise, and this topic is gonna take too long as well, because it is very very long and you need to understand some kind of exceptions also to it. So we'll continue this particular class in the next session as well. Okay? So till then, stay tuned. Like, share, subscribe to my YouTube channel. It's at a very nascent stage. I want the support from you guys as well. And of course, I'm ready to help, because all these videos are completely unfiltered videos, because I'm telling you everything regarding what the coaching institutions do and what the child is supposed to do. Because Clat people are majorly struggling ki mocks mein doubts hai, CR mein udhar udhar doubts hai. So I'm ready to help you guys. Okay. So subscribe to my YouTube channel. Thank you so much. Bye.